review on the application of China Media Limited and the Office of Communications.
Good morning, Mr. Krasinski.
Good morning, my lord. As you know, I appear with Jason Pobjoy for the Appellant Star China Media Limited. My learned friends, Mr. Brian Kennelly, King's Counsel, and David Glenn appear for the Respondent, OFCOM. As my lords and...
Just hang on one second.
Just trying to make my chair go down a bit if I can. I don't think I can, so
I
don't
think
worry.
you
Can I?
on your right-hand side.
Ah, yes.
I sat there recently.
Never mind.
unfamiliar territory.
Being very short, I probably...
It's not working. Thank you. Sorry about that.
I was worried money was going to drop suddenly. As my lord and lady know, this appeal concerns OFCOM's decision of the 8th of March 2021 to impose a financial penalty of £125,000 on the appellant, following its earlier decision that 5 programmes broadcast during 2019 on the television channel called China Global Television Network Service, or CGTN, did not meet the standards of due impartiality in Ofcom's broadcasting code. The relatively narrow, but nonetheless important point of principle raised in this appeal concerns how the strict requirements of proportionality in Article 10 should apply when Ofcom imposes a penalty on a television broadcaster in circumstances where the broadcaster's licence has been revoked, so that the central objective of deterring the broadcaster itself from repeating similar conduct no longer applies. Ofcom rightly accept in their skeleton for this appeal at paragraph 25.1 in the passage I'll show you later, that the revocation of the appellant's licence was a material factor which ought to have been given significant weight in its proportionality assessment. However, in substance, that material change of circumstances, i.e. the licence revocation, made no difference at all when Ofcom made its final decision setting the quantum of the penalty. And that is our primary complaint. Our related complaint, which I will develop later this morning, is that Ofcom's decision on its face failed to consider whether the one remaining regulatory objective of industry-wide deterrence could have been achieved by a reasoned decision along the lines we have set out in our skeleton at paragraph 46, which would have made clear what level of penalty would have been imposed but for the change of circumstances entailed by the licence revocation. That submission formed a central part of our case below, but the judgment of Mr. Justice Swift didn't address it. With that brief introduction, and subject to the court wishing me to take matters in a different order, I propose to start by taking you briefly to the relevant provisions of the legislation and Ofcom's penalty guidelines. I'll then deal with the case law, which is largely common, the legal principles are largely common ground. I'll then take you to the key passages in the underlying documents, and I'll then develop our submissions about why the decision to impose the £125,000 sanction was unlawful. I'll address my friends' arguments in their skeleton, and I'll address briefly why the judge below went wrong. So the relevant legislation is in the...
Could you also address the question of whether the reason for the revocation of your licence is in any way relevant? Because as it seems to me, it wasn't a completely unconnected affair. I haven't seen the material about it.
I'll show my lord the material.
Yes, thank you.
And it's relevant in the sense that it is unconnected. Just to foreshadow what I'll say later on, the reason for the revocation was concerned with who actually had editorial control over the television channel in question, because it is a legislative requirement that whoever holds the license has control, it was found that the appellant company Star China Media Limited did not have such control, and that the entity which the license might potentially have been transferred to, which did have control, was itself controlled by the Chinese Communist Party. And there's a legislative bar on entities controlled by political parties from holding broadcasting licenses. So that the reason that the license was revoked was, in that sense, unconnected from the underlying breaches that gave rise to the penalty in this case.
But that's the point, isn't it? It's not really unconnected because editorial control was in the hands of the Chinese Communist Party. It could be said there was less balance than there might otherwise have been.
Well, can I think about that question, my lord? Ofcom's skeleton and its reasons, and the judge below, did not suggest that there was some connection between the license.
No, I know. That's why I'm asking.
Yes.
Yeah.
What I don't know if this is what my lord has in mind. What I can't positively submit is that the license revocation was some indirect penalty connected to the content of the programs that were subject to the sanction in this case. I can't say they are entirely unconnected for the reasons that my lord has canvassed. But I don't think either side goes so far as to say that the license, or undoubtedly, the license revocation was a serious interference with Article 10. All the penalty guidelines and it's make clear and it's
license revocation was a breach of Article 10.
No, I don't say it was a breach. It was an interference, and it's not my role here to argue that it was an unjustified interference. That's not part of our case in these proceedings.
No. Okay.
So just to pick up the Communications Act, it's Authorities Bundle 24. Starting with section 3, page, my lords and lady working electronically, I'll give you the page numbers. It's page 927, tab 24, page 927.
Yep. Gosh, we're all working electronically today. It's wonderful.
And hopefully my page numbers will match my lords and ladies' page numbers. I hope page 927 is General Duties of Ofcom, section 3.
Yep.
Section 3.1a, which will be the principal duty of Ofcom in carrying out their functions to further the interests of citizens in relation to communication matters. Then subsection 2, the things which, by virtue of subsection 1, Ofcom are required to secure in the carrying out of their functions, include in particular each of the following, ... E, the application, in the case of all television and radio services, of standards that provide adequate protection to members of the public from the inclusion of offensive and harmful material. Then subsection 3, in performing their duties under subsection 1, Ofcom must have regard in all cases to the principles under which regulatory activities should be transparent, accountable, proportionate, consistent and targeted only at cases in which action is needed. So the requirement of proportionality, as well as being embedded in Article 10, is expressed on the language of the Act.
So
Subsection
3.3.1, is it?
3.3a.
3.3a, yeah. Mm-hmm.
Then 3 sub 4, Ofcom must also have regard in performing those duties to such of the following as appear to them to be relevant in the circumstances. ... G, the need to secure that the application in the case of television and radio services of the standards falling within subsection 2e and f is in the manner that best guarantees an appropriate level of freedom of expression. That's section 3. The due impartiality standards, which the appellant was found to have breached and which led to the penalty in this case, was contained in the Broadcasting Code made under the varies conferred by section 319 of the Act, page 936. My Lords, the Master of the Rolls and Lord Justice Warby may recall this legislative framework from the TV.
Well, I'm just following my judgment in Novosti, which so far has cited every section you've...
It has, my Lord. And that's why I'm going to take this briefly.
I mean, so we do sort of know.
You're familiar.
I've picked it up too.
Okay.
My lady's pretty quick on the uptake, so she'll be...
I will speed through. So my Lord and Lady will see that section 319 sub 1 sub 2c refer to the due impartiality standards for news. Subsection 3 requires Ofcom to set out the standards in a code. Subsection 320 at page 941 have what are called special impartiality requirements for, in a nutshell, matters which constitute matters of political or industrial controversy and matters relating to current public policy. So,
which this is.
There's no doubt that this is. The penalties were set in this case pursuant to the powers conferred by section 392. That's page 947. There, I beg your pardon. The penalty itself was imposed pursuant to section 237. That's page 932. Penalties for contravention of licence conditions. So 932, if Ofcom is satisfied that the holder of a licence to provide a television licensable content service has contravened the condition, they may serve on him a notice requiring him to pay them a specified penalty. The amount of the penalty mustn't exceed the maximum under subsection 3, and the maximum is whichever is the greater of £250,000 and 5% of what's called qualifying revenue for the relevant period. So that's the power to impose a penalty. Then there is the requirement in section 325 to observe the standards code. That's page 943. That's why the penalty regime arises, because if you breach a provision of your license under section 325, you are exposed to the possibility of a penalty under the provision I just showed you. So section 325 requires you, specifically in section 325(1)(a), to comply with the standards set in section 319. Section 392 imposes a duty on Ofcom to prepare and publish a statement containing guidelines that they propose to follow in determining...
I'm sorry, which page is 325?
That's 392 is at 947. So subsection 1 imposes a duty on Ofcom to publish penalty guidelines, and subsection 6 requires Ofcom, in determining the amount of any penalty, to have regard to its own guidelines. And then the final section to refer you to is section 346 at page 946. There was some considerable discussion about the legal relevance of this provision in the court below, although ultimately the judge, in a passage I'll show you in a moment, came to what both parties, I think, accept as the correct conclusion. So 3461, this section applies to the following amounts, and then it's B, the amount of the penalty imposed by Ofcom under ... this part of this Act. subsection 2 states that every amount to which this section applies shall be recoverable as a debt from the person obliged to pay it. And then subsection 3, in a nutshell, says that that penalty is not affected, or rather the liability as a debt constituted by the penalty is not affected by the fact that a licence is no longer in force. The judge below canvassed the possibility and argument that that provision positively required OFCOM to impose a penalty on the basis that the licence had not been revoked, i.e. effectively to ignore the licence revocation. But ultimately, at paragraphs 31 to 32, he correctly found that that was not its effect. And that is common ground. There's no respondent's notice seeking to argue that he should have found any differently.
Does no more than preserve the power to
Recover.
enforce and recover.
Precisely so, my lady. That's all I need to show the court on the legislation. The penalty guidelines, we can put away the authority bundle at least for the moment. The penalty guidelines are in the supplementary hearing bundle, starting at page 208. Published pursuant to section 392, which I just showed you.
Sorry, can you give me that page number again?
The cover page is at 208.
Yeah,
The substance starts at 211.
thank you.
Could I just invite the court to read to itself paragraphs 1.1 to 1.6 inclusive?
Yeah.
I'll come back to those paragraphs a little later on. Can I just ask you to look at one other, which is 1.11? One point I want to flag up now concerns the reliance in my learned friend's skeleton argument in this court on the objective of punishment. As I'll show you later, the only objective of the penalty regime that was relied upon on the face of OFCOM's decision and in their statement of case in the judicial review and in the skeleton argument below was the objective of deterrence, both specific deterrence to the broadcaster in question and general deterrence of the wider broadcasting community. It was not suggested in the written arguments below or in the OFCOM penalty decision itself that a freestanding objective of a penalty under the guidelines was that of punishment, as for example a criminal penalty is obviously intended to punish the defendant for his wrongdoing, as well as serving the objective of deterring him and others from repeating similar conduct. So in that context, it is relevant to note that apart from the one use of the word punish in the opening sentence of paragraph 1.3, where I would respectfully suggest that that word is being used as a synonym for the word penalise, i.e. Ofcom has powers to penalise those who act unlawfully. Apart from that one use of the word, there is no mention at all in the penalty guidelines set pursuant to section 392 of punishment being a freestanding objective. But as I will show you later, there has now been a shift in Ofcom's written case in that they suggest that maintaining the sanction of £125,000 was required for the purposes of punishing the appellant, notwithstanding the revocation of the licence. And that's the penalty guidelines, at least for now. The last framework or policy document I'd like to show you is in the same bundle, the supplementary bundle, starting at page 200. This is not a document that has any statutory basis. That's not a complaint, it's just a fact. It's not published pursuant to section 392 or any other provision. It's simply there to set out what procedures Ofcom will follow when deciding whether to impose a statutory sanction. So the summary of what it does can be found in paragraph 1.1 on page 201. I could just invite you to read that. And the procedure that it will follow can be found at paragraphs 1.20 to 1.23 on page 205. If I could just ask you to read those 4 paragraphs. I'll come back to the relevance of the second sentence in paragraph 1.20 in the course of addressing my learned friend's submission. So a case will normally be considered for the imposition of a sanction when Ofcom considers that a broadcaster has seriously, deliberately, repeatedly or recklessly breached a relevant requirement. Then paragraph 1.28, if the court could just read that.
Sorry, can you say the paragraph?
1.28. And then finally, 1.31 and 1.32 on page 207 simply make clear that Ofcom publishes its sanction decisions on its website, as well as a summary thereof. And that will be relevant to the submission I make later on concerning how Ofcom could and should have dealt with this in an alternative way.
I mean, is is this a case in which we can consider, are you saying there should be no financial penalty?
Well, my lord, part of what I'm going to address in due course concerns Ofcom's submission that the logic of our position entails that there had to have been no penalty at all. We would certainly say that a decision to impose no penalty, coupled with a properly reasoned decision, making clear what penalty would have been imposed but for the licence revocation, would have been a rational and proportionate response, and I'll develop that submission in due course. But we do not need to go so far as to say that a zero penalty was the only lawful response. So if, for example, Ofcom had imposed a penalty of, say, half of the original £125,000, coupled with a published decision saying that in light of the licence revocation we are reducing the penalty by 50%, say, to reflect the fact that there is no longer any need for individual deterrence, but that some financial penalty is still appropriate, we would have been in much greater difficulty in advancing our case. What our simple point is that what Ofcom could not lawfully do was impose a penalty that simply did not reflect the change in circumstances at all. And that's a submission I'll develop.
If they'd said, if they had said, rather than we're proceeding on the counterfactual, we have considered the fact that there's been a revocation, but we consider nonetheless general deterrence is so important in this context, having regard to etc., etc. Would you have had an argument?
We would, my lady, and it might have depended on... Well, that's essentially what they're trying to recharacterise their decision as being
I know,
now.
but is this a reasons challenge?
No, and Ofcom place a lot of emphasis on the approach of the Supreme Court in the Denby High School case and in the misbehaving case, saying the question for the court is of substance, not of procedure. Although, as I will also be submitting, in circumstances where the reasons later advanced by a decision maker do not appear on the face of the decision, that will go to the deference to be paid by the court.
I understand that, but isn't what you're doing then ultimately a reasons challenge?
No, with respect, my lady, what I'm entitled in the course, a central part of Ofcom's defence of this case is that we are the expert regulator. You, the court, although considering the substantive proportionality for yourself, are not in the shoes of the expert regulator. You should give us significant deference. Yeah. And part of my response to that is saying that submission has much less weight in circumstances where the reasons now relied upon are ex post facto reasons. So I'm entitled to point out that they are ex post facto reasons without mounting some Ermakov common law type argument concerning reasons itself. So can I deal briefly with the relevant case law, largely because it's either common ground and or set out in the judgment of this court in the TV Novosti case. First, it's common ground that the imposition by Ofcom of a penalty in this case entailed an interference with the appellant's Article 10.1 rights, so that it then fell to Ofcom to justify that interference. Secondly, as to the approach to be adopted in deciding whether the interference was justified, could I take you to the judgment of this court in the TV Novosti case? That's Authorities Bundle, starting at page 905, tab 23. For my lady's benefit, but as I'm sure my lady already knows, that case involved a challenge by the broadcaster of the RT News channel to Ofcom's decision, finding it in breach of the due impartiality requirements under the Code, the main argument advanced for the claimant was that in deciding whether the standard had been breached, Ofcom should have taken into account what we call the dominant media narrative about the relevant events. Both the Divisional Court and this Court rejected our argument, but prior to that rejection, my Lord, the Master of the Rolls' judgment, with whom my Lord Justice Warby and Lord Justice Baker agreed, accepted the claimant's summary of the relevant legal principles. Can I just show you paragraph 23 of the judgment, page 914, invite you to read that. So that cites Lord Hope in Shaler about the need for a close and penetrating examination of the factual justification for the restriction, and a citation from Strasbourg in the Animal Defenders case of the need scrupulously to examine the proportionality of a restriction. And then paragraph 47 on page 921, if I could invite the court to read paragraph 47. And it's the penultimate sentence of paragraph 47 on which I place particular emphasis.
Got to be proportionate.
Got to be proportionate, and there has to be a close and penetrating examination of the factual justification for the restriction.
Yeah.
But it's a question of substance.
It is a question of substance. And then can I just penultimately
And that
remind
applies as much to penalty as it does to decision.
It does. Can I just remind the court then of the well-known passage on proportionality in Lord Sumption's judgment in the Bank Mellat case? That can be found starting at tab 15, the relevant passage in paragraph 20, which starts at the foot of page 577 of the bundle. This is Lord Sumption, with whom Baroness Hale, Lords Kerr and Clark agreed. And in particular, it's the summary by Lord Sumption at the top of page 578, which, after having cited the milestone cases of De Freitas, Daly, Huang and Keeler, sufficiently summarised the principles in 4 Roman numerals. And I particularly, as the court would expect, focused on Roman numeral 3, whether a less intrusive measure could have been used, which is then expanded upon at letter D by Lord Sumption, saying the question is whether a less intrusive measure could have been used without unacceptably compromising the objective. And for your note, that language of whether a less intrusive measure could have been used without unacceptably compromising the objective was also picked up in Lord Reed's judgment at paragraph 74 at the top of page 598 at number 3, just above letter B on page 598, whether a less intrusive measure could have been used without unacceptably compromising the achievement of the objective. So Lord Reed dissenting in the result, but concurring in that part of the reasoning.
Sorry, I'm just a bit behind you. It's paragraph 74.
Paragraph
Which
74,
number?
top of page 598.
Which number?
Number 3. So, drawing all that together, in our submission, those passages show that what is required in this case is a close, penetrating, scrupulous examination of the factual justification for the penalty in order to determine whether or not a less intrusive measure could have been used without unacceptably compromising.
I want you just to take this a bit more slowly.
Yes.
I'd like to write it down and you're rattling on, if I may say so. A close, penetrating, scrupulous examination
of the factual justification for the penalty.
Yeah.
In order to determine whether a less intrusive measure could have been used without unacceptably compromising the relevant objective. And the relevant objective here, as the court will understand, is that of general deterrence.
Yes, thank you.
Of course, we entirely accept, as Ofcom emphasise, that the need for rigorous scrutiny does not mean that the court should adopt the mantle of the primary decision maker. And likewise, we accept that a margin of discretion must be afforded to Ofcom to decide how best to achieve the relevant objective, and that that is a question that might not admit of only one answer. Nonetheless, as the case law makes clear, the margin of discretion is particularly narrow in an Article 10 case concerned with political free speech, and the existence of that narrow margin obviously doesn't displace the need for a close and penetrating examination of the kind I have described. The only other point of principle to make in terms of the margin of discretion is the one that I was discussing with my lady a few minutes ago. Namely, that if the reasons which are later advanced by a public authority to justify its decision do not appear on the face of the decision itself, that will be relevant to the weight and hence the deference to be given by the court to the decision maker's evaluation of the competing considerations. Ex post
The decision makers what?
evaluation of the competing considerations.
of the competing consideration.
Yes, sometimes the case law says a regulator is charged by Parliament with the primary statutory duty to decide what to do. It will weigh up the competing considerations. Deference should be given by the court to that evaluation. But if the evaluation is not apparent from the face of the decision, the room for deference to that evaluation obviously shrinks.
Well, the room for deference might, but does the validity of it, if it's valid, shrink?
Well, as a general rule in my respectful submission, ex post facto reasons, just as in the common law world, ought to get less weight than reasons that are apparent from the face of the decision. And I say that for two reasons. One is, if the new reasons were so compelling, one would have thought they would have appeared on the face of the decision.
Well, that assumes that public authorities are infallible. They may or may not be.
Well, I certainly don't say that Ofcom is infallible in this case, my lord.
I'm sure they did.
And secondly, there is the tendency discussed in all that common law jurisprudence on ex post facto reason for a decision maker faced with a challenge to his or her or its original decision to come up with self-justifying reasons, which tends, in my respectful submission, to carry less weight. I mean, there was a time when it was asserted by some at least that ex post facto reasons were actually inadmissible as evidence. I don't think I'm certainly not going that far in this case, but I do say they carry less weight for the two reasons I've just identified. And then finally,
I find all this slightly puzzling, I have to say, because if we're undertaking a close, penetrating, scrupulous examination of the factual justification for the penalty, surely we're entitled to look at all factual justifications for the penalty.
I entirely agree, my lord. I'm not suggesting the court should not scrupulously examine all of Ofcom's reasons, including its reasons as advanced subsequent to the decision. I'm just saying that if reasons are new, not apparent from the face of the decision, they may carry less weight in your scrupulous examination.
But they may do.
They may do.
I mean, I completely understand they may do. I mean, if they come up with something that's a stupid support for what they'd said before and doesn't really add up to the price of beans, probably we wouldn't take any notice of it. But if they suddenly have some Damascus conversion and say, oh, the real reason must have been this, sorry, we didn't think of it before,
and you're persuaded
we think
by
it's absolutely crucial, then it doesn't help you.
I entirely agree.
Yeah,
with respect.
so really we've still got to do a close penetrating examination and
Yes,
take our own view as to whether it's justified or not.
I would entirely accept that, my lord. And to go back to my lady's question, this is not just a reasons challenge.
No.
I'm not asking you to remit this case on the basis that the reasons were no good, therefore go away and think again.
And even less so as far as the judge's decision.
Yes, I'm entitled to complain, as I do, that he didn't address the main point. But I'm not inviting you to allow the appeal and to forfend. It's just remit it again for another first instance decision.
You say the judge didn't address the main point at all?
Well, we spent quite a bit of time below discussing what alternative decision Ofcom could and we said should have made, in the same way that I'm going to spell it out to this court. And for whatever reason, the judge did not address that. he certainly did address our central point that if £125,000 was the appropriate penalty at the time of the preliminary review, it couldn't have been the appropriate once the licence revocation had taken place. But he did not address the submission that we developed, which we developed below in writing and orally, and had made at the permission hearing, that a differently expressed decision could have achieved the remaining regulatory objective of general deterrence. And then finally, in the authorities bundle, can I take you to the decision of this court that was mentioned by my Lord Justice Warby in the order granting permission to appeal in this case, which is the decision in Panel and Business F1 magazine. That starts in the authorities bundle at page 326. It was a case brought by the racing driver about the proper approach to courts awarding damages for libel. So it obviously wasn't a case about a regulatory decision and therefore is only indirectly relevant in this case. Nonetheless, the proposition which one can derive from the judgment of Lord Justice Laws, with whom Lord Justice Evans, Long and Chadwick agreed, and which I don't actually understand OFCOM to dispute, is as follows. In considering what financial award to make, in a case which engages the Article 10 requirement of proportionality, it will be necessary for the decision maker to take into account the extent to which the relevant objective will have been achieved by a reasoned decision that is published in conjunction with the financial award. So just to give you a bit of background.
That's your formulation. It's nothing.
Yes.
It's not. There's not wording.
I'm not reading out from the
Where
document.
does that
I'm going to
come
show. I'm going to show you the passages where I derive that from.
It's abstracted from what Lord Justice Laws said.
It's a. I hope a fair digest of what is said. But
Where did he say it?
Paragraphs 24 to 29. Can I just show you? I'll give my lord. Take my lord to the passages in a minute. But just to give you context. So the claimant sued the defendant, magazine, for libel on the basis of an article which suggested that Sebastian Purnell had bribed a journalist for certain purposes to do with his career. The case came before the court and the judge struck out the magazine's defence of justification, i.e. that the allegation was justified, on the basis that on the evidence before the court, no reasonable jury could have concluded that there had ever been such bribery. So there was a striking out of the justification defence. And the judge then directed the jury that in making their damages award, they could take into account an element to reflect the need to vindicate the claimant's reputation. The jury awarded £75,000 and the magazine appealed on the basis that the reasoned judgment of the court striking out the justification defence had provided all the necessary vindication of the claimant's reputation.
What had?
The reasoned judgment striking out the defence of justification. So the magazine said, well, you've got a reasoned judgment that makes it clear that your reputation has been vindicated. So why does any financial penalty have to achieve that aim as well. And that was the basis of the appeal. And that was dealt with by Lord Justice Laws in the passages I mentioned earlier. So if my lords could, and the lady could, pick up the authorities bundle at page 338. The judge says, there are in theory, this is the first line of page 338, there are in theory no doubt 3 possible positions to be considered where damages for defamation have to be assessed in a case where there is also a previous judgment dismissing a justification defence with reasons. First, the earlier judgment should always be taken into account by the tribunal assessing damages as extinguishing the need for any element of vindication to be reflected in the damages. That was the position adopted by the defendant. Secondly, the earlier judgment should never be so taken into account. Third, the earlier judgment may be taken into account by the damages tribunal depending on the latter's view of its impact on the vindication issue. Mr. Price, that's the counsel for the defendant, adopts position 1. Mr. Bennett says Dingle vouchsafes position 2. Then the conclusion is paragraph 27, just below letter F. It seems to me inescapable the existence of a prior reasoned judgment rejecting a justification defence, and so holding that the claimant has indeed been libelled, is at least capable of providing some vindication of the claimant's reputation. If that is right, then the court assessing damages must surely see whether it does in fact provide such justification, for otherwise the court would fail to make a complete or comprehensive judgment on this issue of necessity, and would be at risk of failing in its duty to uphold and apply the Convention rights. More broadly, it is, in my view, important that an assessment of damages be arrived at in light of all the relevant circumstances, and again, the prior reasoned judgment is surely capable of amounting to a relevant circumstance. So that is why I sought to digest those passages in the way that I did earlier. That's all I want to say on the case law.
I mean, it's a very different situation.
It is, my lord. The relevant objectives are somewhat different. It's not a regulatory objective. The relevant interests are not the same because this isn't one private party, in our case, suing another. Nonetheless, the broad point can be made that if you're going to conduct a scrupulous examination of the strict need for a financial award, you've got to take into account the extent to which a reasoned decision, in that case, the reasoned judgment striking out the justification defence, in this case, the penalty decision, can actually achieve the objective itself without the need for either any financial penalty or a financial penalty that...
I think what I had in mind was the rather basic point that the objectives in both cases are changing other people's minds about
Yes.
things. In libel, persuading people that the claimant is not the person he was depicted to be in the libel. In this context, persuading other broadcasters or other licensees of OFCOM that they shouldn't do the kind of things that these people have done.
Yes.
And there are at least 2 ways in which you can try and do that. One is by saying something, and the other is by arriving at a figure, a number, in money terms, that is targeted at the same end. And there'll be a range of circumstances in which one or other of those ways of doing it may be effective. Sometimes, as
or a
this
combination
decision
of the two.
indicates, saying what you've got to say in a long judgment about how there's no justification will be ignored by the public because it's not the way that people react to judgments of the court. Maybe in other circumstances it might be different. That was all, really.
I'm grateful. And essentially, Ofcom's case might be boiled down to saying, in this case, what matters is the money.
Yeah.
Yeah.
Which is often said in libel cases.
Yes. But I'm going to make my submissions shortly. about why that was the wrong approach. So just very briefly taking you through the primary documents, largely to locate them in the chronology, because the key passages are actually relatively limited in their scope. So the original breach decision, just so you can see where it is in the supplementary bundle in the first tab. It was made on the 26th of May 2020. It's quite hard to read, but in the top left-hand corner, there's the date.
So which page is it?
3,
Of
supplementary bundle.
May 2020.
26th of May 2020. If my lords and lady could just read the summary in parallel to what would be, if you had hard copies, the lower whole bunch. And then the introduction and summary through to the following page. You don't need to go any further than stopping just above the heading background. And then if my lords and lady could turn to the final page of that decision, I don't propose to go through the detail. Page 63 of the bundle. Under the heading Next Steps, if the court could just read from Next Steps to the end of that page. That's May 2020. November 2020, OFCOM published their preliminary view on sanction. That starts at the next page, page 64. And just to flag up the obvious point, that at the time of the preliminary view, the appellant still held its broadcasting license. I just want to show you the structure of the preliminary view rather than to go through it all in detail. Paragraphs 1 to 10 on pages 65 to
When you say published, it is actually published, is it?
No, I beg your pardon. It's sent to the licensee.
Yeah. Yeah.
So paragraphs 1 to 10 contain a summary of the preliminary view, concluding at paragraph 10 in saying that Ofcom's preliminary view is that the appropriate sanction is a financial penalty of £125,000 and the direction to broadcast a statement of Ofcom's findings. Paragraphs 11 to 25 set out the legal framework, and in due course you may wish in particular to look at paragraphs 16 to 18, and we have no complaint about the legal self-direction in those paragraphs. So, for example, we have no complaint, indeed agree with, the sentence at the foot of page 66, which says, while subject to exceptions, the need for any restriction must be established convincingly. There's then a reference at page 68 in paragraph 23 to the divisional court's judgment in the TV Novosti case, because at the time of this preliminary review, one had reached the stage of the divisional court's judgment, not the Court of Appeal's judgment.
Well, we upheld the divisional court.
You did, albeit for slightly different reasons. Then, at paragraph 30, there's a summary of the appellant's representations against the sanction, although at the time they did not include any mention of the licence revocation because that had not yet happened.
Had there been any minded to communication about that?
Yes, I can't remember whether by that, what stage the revocation process had reached. I hear whispers from the other side of the court that the answer to my Lord's question is yes. I
thought that that was part of their scale argument.
The reasoning to justify the preliminary view starts at paragraph 32, and it's divided into two broad sections. The first section of the reasoning is concerned with OFCOM's view, or preliminary view, about whether the breaches were, quote, serious, deliberate, reckless, or repeated. And that starts at paragraph 33 and continues through to paragraph 45. Paragraphs 46 through to 56, in summary, concluded, at least on a preliminary basis, that it was necessary to direct the appellant to broadcast a statement of Ofcom's findings on the breach, and also to impose a financial penalty. So
42, is that?
46 to 56. And I just invite the court to look in particular at 56 under the heading financial penalty. That's page 74, paragraph 56. It says, Ofcom didn't consider a direction alone would be a sufficient sanction, having regard to the seriousness of the breaches and to the need for it, that's the sanction, to act as an effective disincentive to discourage the licensee from repeating similar breaches of the code, brackets, or other licensees from contravening the code in a similar manner, close brackets. Ofcom's preliminary view is therefore that it would be proportionate to impose a financial penalty in addition to the direction. And then paragraphs 57 all the way through to 77 discuss the factors relevant to the quantum of the penalty. I'm not going to go through the detail. Paragraphs 78 through to 84 then discuss what are called, in the language of Ofcom's decisions, precedent. They're not really precedent in any Young and Bristol aeroplane law of precedent type meaning. What they really mean is previous sanction decisions that are said in one way or another to provide some guidance as to the current situation. But as Ofcom are always at pains to emphasise fairly, see, for example, paragraph 78, line 2, each case is decided on its own facts. And none of the cases discussed in paragraph 78 through to 84 were said by Ofcom to be materially identical or even very similar. They just had some features that were either different or similar and guided Ofcom towards the relevant figure. But then for present purposes, my lords and lady, the most important part of the preliminary view is at paragraphs 85 through to 95. Paragraph 85 says, as set out in our penalty guidelines, the central objective of imposing a penalty is deterrence. The amount of the penalty must be sufficient to ensure that it will act as an effective incentive to ensure compliance having regard to the seriousness of the infringement, OFCOM will impose a penalty which is appropriate and proportionate and which will act as a deterrent, taking into account the size and turnover of the licensee, i.e. licensee focused. Paragraph, if my lords and lady could just read paragraphs 86 through to 88. And then, most importantly, 93 through to 95.
Yeah.
So 2 points to draw out from those passages, in particular 85 to 87 and 93 to 95. First of all, there is of course mention of deterrence to other broadcasters, but the primary focus, at least in these passages, is on deterring the licensee itself from repeating similar conduct.
Is that right? 95 is fairly clear that it's other broadcasters, and there are references to other broadcasters elsewhere.
Yes, I'm not disputing there's no mention of reference to other broadcasters. I'm just saying that the predominant focus...
But why do you say that? I read it as both of them are a focus.
Well, for example, paragraphs 85 and 86 concern the taking into account the impact it will have on the licensee itself, bearing in mind its own turnover.
Because it's required to look at size and turnover.
It is.
Of the regulated body.
It is. The second point I wish to draw out is that there's no mention in the preliminary view, as there will be no mention in the final view, of achieving an objective of punishment as a freestanding objective separate from specific or general deterrence. So that was the November 2020 preliminary view. Next in the chronology were the appellant's written submissions or representations on that preliminary view, which, just to locate them, are at pages 186 through to 190. And there's a helpful summary at page 190. But as I said before, this was before certainly the final decision on revocation, and so did not make a reference to that. The next stage in the chronology is the license revocation. That was the 4th of February 2021. Supplementary bundle tab 3 starting at page 86. And to answer my Lord the Master of the Rolls' question, a helpful summary of what gave rise to the revocation decision can be found at paragraph 9 at page 87 of the bundle, supplementary bundle. Perhaps in light of my Lord's question, it may be helpful just to allow the court a moment to read paragraph 9, subparagraphs A to F. I'm conscious that my Lord had some questions for me about this earlier. I'm happy to answer any further questions.
Well, I mean, it's exactly as you said, right?
Avogador would like to hear that. Right, well, I'll move on.
Well, I mean, it's exactly as you said, but I mean, it is connected for the reasons I said. That, I mean, their license was revoked because the true license holder was always going to be the Chinese Communist Party, which is a political
So Ofcom
organisation.
concluded. So Ofcom concluded.
So Ofcom concluded, and that was obviously, therefore, what had been happening on the ground in the events which gave rise to the sanction we're considering, namely broadcasting imbalanced material. That was the view and perspective of that organisation. I mean, to say they're unconnected is not really right. I mean, they're not the same thing. Different statutes apply and different considerations apply, but they're not unconnected. So I don't know why anybody ever said they were.
Perhaps it's better to say they're separate.
Yeah, they are separate, yes. Separate but connected.
Can I then, in the chronology, take the court to the final sanction decision? It's in the core bundle. The court may, of course, wish to read the whole of this in due course, but I can take it relatively quickly. The core bundle, starting at page 163. The decision itself can be seen at the foot of page 163 to impose a financial penalty of £125,000.
What's the date?
The date is the 8th of March 2021. And that can be seen at the foot of page 183. So just picking up a few key passages, starting at page 164, there's a reference in paragraphs 7 and 8 to the license revocation and to the fact that that doesn't prevent recovery of the penalty, imposition of the penalty under section 346 of the Act. Then the decision itself is contained in paragraphs 9 and 10.
Yes.
Just as in the preliminary view, there is then a recitation of the legal framework. We don't complain about self-direction in that legal framework. The operative part of the decision starts at paragraph 44 and essentially repeats the contents of what was said in the preliminary view. I'm not going to go through it all. It follows the same structure, including dealing in some detail with what they call precedents, starting at paragraph 87 through to 95.
Is it your submission there's no difference between the way that precedents are dealt with in this final decision and the earlier?
No, I don't know. The reason I'm focusing now on the time spent in the decisions on precedents is that part of Ofcom's defence in this appeal is that other broadcasters won't really understand a reasoned judgment or a reasoned decision along the lines we say they should have published, because they won't really understand the difference between one case and another. And what I'm going to be saying is, look, these penalty decisions, both this one and the other precedent cases in the bundle, showed that Ofcom have quite lengthy decisions setting out their reasons and comparing and contrasting one case to another. So it's a little difficult for them to say in this appeal, well, we couldn't have had a reasoned decision that made clear that this case wasn't like a case where a licence holder surrenders its licence in an attempt to avoid a penalty, because other broadcasters won't understand that. And I'm simply drawing...
Yeah, what I had in mind is another feature of the argument, which is that there was a precedent for taking the view, an Ofcom precedent, for taking the view that the revocation or cessation of broadcasting was not a factor that should make a difference.
There's the Club TV case, my lord.
The May 2021.
And to foreshadow the submission I'm going to make, is that there is, to echo Ofcom, each case depends on its own facts. And there's a world of difference between the fact of that case, where following a breach, the relevant licensee, I think it was called Peace TV or Club TV, surrendered its license voluntarily and then said, oh, now there's no need for individual deterrence. And this case, where there was a revocation of the license, not a surrender, and I'll be developing that point in due course.
But so far as the reasoning is concerned, and we've already had some discussion about how relevant that is.
Yes.
I hadn't detected in my reading a difference, anything in the discussion of precedents in the final sanctions decision.
That's different.
That said, now we've got to take account of the Club TV case because in that case there was a surrender of the
No,
license.
it's a bit of ex post facto reason.
Yeah.
In the submissions for the
Well, Mr.
judicial
Keneally
review.
may tell me differently, but
No, I think,
that's your position.
well, my learned friend's skeleton argument, in an attempt to show why what they did in this case was consistent with their previous cases, says, look, we referred among over a dozen other cases to Club TV, so we must have had it in mind, I think is the short submission he makes. But I'm going to, that's not reflected in the terms of the decision.
Yeah, we'll let Mr. Keneally say what
Yes.
he has to say about his submissions, but I just want to know what you said about them.
In terms of the core passages that I do draw attention to, it's paragraphs 96 through to 99 on pages 182 to 183. In particular 96, where they say, as set out in our penalty guidelines, the central objective of imposing a penalty is deterrence. The amount of any penalty must be sufficient to ensure it will act as an effective incentive to ensure compliance, having regard to the seriousness of the infringement. SCML, that's the appellant, no longer holds a broadcast licence following Ofcom's decision to revoke the licence, and the CGTN service has ceased broadcasting in the UK. Therefore, there is no longer a risk of future non-compliance by SCML or in respect of the CGTN service in this case. Nevertheless, Ofcom is concerned to ensure that enforcement against serious breaches of the code acts as a wider deterrent against non-compliance by broadcasters in general. Accordingly, Ofcom considered what would be an appropriate and proportionate sanction which would act as an effective deterrent had SCML continued to hold a broadcast licence and the CGTN service continued to be broadcast, taking into account the size and turnover of the licensees and broadcasters and of the licensee and broadcasters and audience's rights to freedom of expression under Article 10, ... Paragraph 98, £125,000, and then paragraph 99, essentially, well, if I could invite the court just to read paragraph 99 and 100. So essentially, Ofcom's reasoning was that in order to ensure that the penalty served the purpose of general deterrence, OFCOM had to impose the same sanction as it would have done if the appellant had still held the licence. So as I said in opening, in substance, the licence revocation made no difference to what Ofcom considered to be the appropriate amount of the penalty. And in our submission, that approach was not lawful. Ofcom concede fairly in their skeleton argument that the licence revocation was a material change in circumstances. Could I just invite the court to turn to my learned friend's skeleton, core bundle, tab 17, paragraph 25.1 on page 232. Paragraph 25.1 says, it's not disputed that the revocation of SCML's licence was a material factor which ought to have been given significant weight in Ofcom's Article 10.2 proportionality assessment. And my lords and ladies see that fair concession. But as I said in opening and as we made clear in our skeleton, if a sanction of £125,000 was the necessary penalty when Ofcom's objectives were both to deter the appellant itself from repeating similar conduct and to achieve general deterrence of the wider broadcasting community, we say it was not still necessary for precisely the same penalty to be set when the first of those two deterrence objectives had fallen away. And that is so, my lady, irrespective of whether you read the relevant paragraphs that we were discussing before as concentrating primarily on specific deterrence or equally on both.
Well, can you just help me? I mean, this assumes, I mean, I'm the worst person in the world to take a sentencing analogy, but I'm going to anyway.
I think I might beat my lord to being the worst person in the world to discussing criminal sentencing. But
Yes, well, I mean, this sort of, if you publish a decision and you say, I am sentencing you to £75,000 to deter you personally and £75,000 to deter others, and
cumulatively or
and the cumulative fine is therefore 150,000, and that's one thing.
yeah.
But actually, it's not logical, is it, to say that that's what they're doing. What they're trying to do is achieve two objectives, and after revocation, one objective. And it doesn't follow that because 150,000 would have deterred both you and others, that 75 or 999 will deter others. I mean, the question is, for them, what will deter others? And it doesn't at all follow that it would be less than the amount that would have deterred others before.
Well,
Does it? I mean, that's my question.
I think my lord has, with respect, encapsulated the essence of Ofcom's argument in this court. They say this was not a 75 and 75 or 67.5 and 67.5 equals 125. They say 125 served both purposes, and you still needed 125, and one purpose fell away.
Yeah, sorry, I've got in my head it's 150 for some reason, but 125.
Yeah.
Yeah.
But my lord, that's with respect, a fair summary of Ofcom's case. And our case in response is, when one of the objectives falls away, you don't need 125 for that. You have to ask yourself the question: could the remaining regulatory objective of wider deterrence have been achieved in a less intrusive way, either by a smaller penalty coupled with a reasoned decision, or no penalty coupled with a reasoned decision? And the reasoned decision that we've suggested in our skeleton should have been published was along the following lines. Ofcom could have said, in our preliminary view, we considered that £125,000 was the appropriate penalty, taking into account all the circumstances as they pertained at the time, given what was then the important objective of deterring SCML from future similar breaches of the code, coupled with the objective of wider deterrence. But since then, the licence has been revoked, and so the first of those objectives is no longer relevant. But for the licence revocation, we would have maintained the £125,000 penalty. But given the relevant change in circumstances, and given that there is no longer a need to deter SCML itself, it is no longer necessary to maintain that level of penalty.
But I mean, it could have done that. But the question is, was it no longer necessary? And
that's the question for the court, my lord.
Well, their view was it was still necessary to deter others.
Yes, and
what I'm struggling for is why you say that's wrong as a matter of law. You say it's unlawful. I mean, you said a minute ago this was an unlawful approach.
Well, because unless there's unless on a scrupulous examination there is a convincing justification why they had to maintain it at 125, the requirements of proportionality set out in the case law will not have been met. It's not enough for them simply to say, we thought 125 was still necessary, full stop. One has the court carrying out its role. Sorry, my lady is going to ask me a question.
Well, I was just going to, but there isn't a straight line correlation, as the judge put it, between specific and general deterrence.
I think the judge put it in paragraph 62. He said the premise of our case is that there's a straight line correlation. We're not suggesting there has to be a straight line correlation.
Well, there isn't. There can't be, as my lord just put to you.
But the question is, could a less intrusive measure have been imposed by Ofcom that would not have unacceptably compromised the objective of wider deterrence? So I asked the rhetorical question. If Ofcom had published a decision that said we no longer need specifically to deter SCML, it's not going to be doing this again, whatever we do, because it's no longer got a license. What is the remaining regulatory objective? It's that of wider deterrence. Can we make clear through our reasoned decision that this is what we would have done? We would have imposed 125 on SCML, but for the licence revocation. So other broadcasters should be in no doubt that if they were in materially similar circumstances and still had their licence in place, they're going to get 125. But we can't justify that anymore because that need for specific deterrence doesn't apply. So we're going to either give no penalty at all or a significantly discounted penalty.
But you can't say that that's the only way to achieve the least restrictive measure.
Why?
Because hitting them in the pocket may be regarded as the only way to achieve that wider deterrence.
Why is hitting SCML in the pocket necessary to deter others?
That's not what it's about. It's about telling people this is what you get charged if you do this.
But why can't that be done, my lord, by saying this is what you get charged if you do this, unless your licence is revoked?
Well, what's that got to do with anything? The others are not really very interested in your client. They're only interested in the read across from your client to them.
But that goes back to the question that I canvassed with my...
what their argument would be. I mean, they would say, well, we thought about reducing it, but we thought that would send the wrong message. And our view, as it seems they're saying, is 125 was needed to deter you, and 125 was needed to deter others.
Well,
so when you
then
revoked your license for connected but different reasons, didn't matter.
Well, I know that my learned friend Skeleton says that Ofcom thought about a different approach and said it wasn't the right one, but that's entirely not apparent from the face of the decision. They didn't, I know this is not a reasons challenge, my lady, but nonetheless there's nothing on the face of the decision that said we've thought about reducing either by a factor or to nil the relevant penalty. But for the following X reasons, largely to echo what they've now said in their skeleton argument, we didn't think that would be effective. There seems to have been no consideration at all. What seems to have happened on the face of the decision is that OFCOM felt it essentially had no choice, following its penalty guidelines, to impose exactly the same sanction that it would have done in the absence of the licence revocation. And we can see that, my lady and my lords, from, for example, not only the decision itself, but from OFCOM's first pleaded case, the summary grounds of resistance. Just to show you, tab 11, the core bundle, page 131. Sorry, page 133. Paragraph 22 and 23. Having referred to its own decision and the guidelines, OFCOM said if a penalty issued in respect of SCML's breaches in this case is to have a wider deterrent effect, it needs to be illustrative of the level of penalty that such other broadcasters would risk attracting by similar conduct. There's then a reference to the guidelines, and then it says, in other words, the penalty must be calibrated to the circumstances of the former licensee, just as it would be calibrated to circumstances of an extant licensee in order to achieve a wider deterrent effect. But there's no reason explaining why it must be, other than saying that's what the guidelines themselves require. And in response to that, we argued at the permission hearing, no, that's not necessarily what the penalty guidelines require. Why could you not have a reasoned decision saying it would have been X, but for the licence revocation, but now it's not X? So there's an evolution.
It seems to me that this is expressing the view I put to you, which is that it won't work if there isn't the read across from the other. I mean, I'm being terribly rude to broadcasters if I call them punters, but there isn't a read across from this errant broadcaster to the others who see their "but for the grace of God go I," so I will therefore not do what they did because I might get charged all that money. If they'd charged them 75 with some rather complex, or 60, whatever it is, half or less, a lesser sum, and explained in a convoluted way, well, this is because they've revoked their license, so you can't read across, you should double it and add 50%, maybe it would have been a bit difficult to understand.
No, that is OFCOM's case. With respect, that encapsulates OFCOM's case, which is why, how, with respect to the punters, who are expected to read penalty and breach decisions that run to 20, 30 pages, including...
That may be the point. They don't read them, and all they look at is the bottom line, the amount of money, and they say, gosh, this is going to be expensive, we better stop.
Well, OFCOM say, in their own skeleton argument, that the primary way in which they ensure that broadcasters generally understand what is expected of them is in their reasoned decisions. So if my lords and lady, I'm going to find.
But I'm sure Ofcom think that. That's a little bit like judges thinking that people actually read their judgments.
Well,
but it's not always the case. Sometimes one might even think it's a conceit of the judges to think that.
But how complicated would it be for the punter?
Anyway, show me where they say it.
Yes, I will. Sorry, I'm going to find the relevant passage.
Just waxing lyrical instead of
Paragraph 27.3 on page 235.
27.3 of
page 235 of the core bundle. They say, nevertheless, the wider point that a reasoned decision may sometimes mitigate against the need for a financial sanction is not disputed and lies at the heart of Ofcom's enforcement of the code. Indeed, the primary method by which Ofcom promotes compliance with the code's standard objectives is by way of reasoned decisions, which other licence holders can consider and use to inform their own regulatory compliance.
And I mean, all these broadcasters must have compliance departments.
They do.
mustn't they?
Well, most of them do.
Yeah.
I mean, I don't know, I'm not giving evidence. I'm sure Ofcom is in a better position to answer that question than I am. But one would expect that they will all either have compliance departments or third-party compliance officers who they subcontract the job to, or something like that.
Is one of the factors, as far as I can see, that might have to be considered by another broadcaster in assessing the significance of a penalty would be the scale of their own turnover, because these penalties
Yes.
are tied
They are,
in a broad way
with respect, yes.
to turnover level. So it's not really just you get 125.
Therefore,
for this
absolutely.
kind of offending. It's if you're this size, you get that, and if you're a bigger size, you get something more. And that's reflected, I think, in the way that the case was put in the grounds of defence that you were citing earlier, because in the guidelines which are quoted there,
The guidelines say you have to.
signal to other bodies that misconduct by them would result in penalties having a similar impact,
Yes.
not the same penalty.
No. So it isn't as if any broadcaster can say to itself, "Oh, there's been a breach. X hypothesise, if I committed a similar breach, I'd get a £125,000 penalty."
No.
Every broadcaster has to consider the extent to which its circumstances are similar or dissimilar from the so-called precedent guide in the published decision. So what's so difficult for the punter to read a decision that says, in all the circumstances, SCML would have got £125,000. Given the licence revocation, we are imposing a lesser or no penalty, but punters, licence holders, ought to be left in no doubt that that was because of the licence revocation. And if they seek, and this is the language of Ofcom in the High Court, if they seek to, quote, game the system by surrendering their licence in an attempt...
That won't help them either.
That won't work.
Yeah. Well, I mean, I completely see that point. Yeah. And could you answer another question for me, because I'll forget to ask it. What was the, just roughly, the number of people who watched this channel when it was broadcasting?
Quite small. I'm not sure whether we have the data. If we do, I'll give it to my lord.
But it's in the low thousands. Is that a correct analysis or not?
I would. That sounds right, but I can't verify that. Well, if we can check over the lunch and adjournment and come back to an answer to that.
Yeah, thank you. I mean, obviously it varies significantly, but I believe when we were dealing with the RT case, we were told
Very low number.
the viewership was in the low thousands.
Yes.
Yeah, I mean, sometimes more, but mostly that.
So I've shown my lords the decision. I've shown my lords and ladies the summary grounds of defence, where they essentially said we had no choice. There was then I'm sorry to take forensic points, but they may prove to be important. There's then an evolution in Ofcom's defence in their detailed grounds of resistance. If I could ask you to turn to Core Bundle page 67. They said, paragraph 33, top of Core Bundle 67, the objective of wider industry deterrence taken alone may well, not has to, but may well necessitate a penalty at the same level as the objectives of individual and wider deterrence taken together. no reason to suppose that removing the objective of individual deterrence means that a lower penalty will necessarily be warranted, or that a penalty which is proportionate when assessed against the combined objectives will automatically be disproportionate when assessed against the objective of wider industry deterrence alone. In the present case, OFCOM concluded that the objective of wider industry deterrence necessitated a penalty at a level that matched the penalty it had intended to set before the licence was revoked. So that's a change from the much more rigid approach in the decision itself. But again, there's no reasons given in the detailed grounds, and there was no witness statement filed by OFCOM saying that something about this case meant that we were in the territory where a penalty had to be set in the same way as it would have been set but for the licence revocation. So paragraph 33 appears to envisage that there might be cases where you don't have to take that approach, but the OFCOM somehow reasoned that this was not within that category. But no reasons were given as to why OFCOM came to that conclusion. So where do we find those reasons? They're now presented in Ofcom's skeleton argument for this court. If my lords and lady could turn to the core bundle, paragraph 24 core bundle page 231, paragraph 24.2. Foot of 231 core bundle.
24.2.
24.2. Ofcom reasoned that the serious nature of the breaches meant that the only effective method of ensuring that an appropriate signal was sent in this instance was to continue to calibrate the level of penalty by reference to the penalty which could have been expected to be imposed. In my respectful submission, that is a non sequitur. There is no logical reason why the seriousness of the breaches means that the only effective method of ensuring wider deterrence must be to continue to calibrate the penalty at the same level. And indeed, if that were the answer, then it would be the answer in every case, because as I showed you before under the guidelines, Ofcom only imposes a financial penalty in serious, deliberate, reckless and repeated cases. So what is the category where that will not be appropriate if Ofcom were right?
You can't construe this as a deed, can you? I mean, it's just an argument.
I don't.
Yeah.
But I'm just saying, insofar as Ofcom say that what makes this case fall into the category where you have to continue to maintain the same level of penalty answers seriousness. Why, I ask rhetorically, why is the seriousness of the breach the answer to why you can't give an appropriate regulatory message by a reasoned decision explaining what the penalty would have been but for the licence revocation?
Is there any of the precedent cases where, in a breach of this kind, which is lack of impartiality, they have not given an upscale penalty?
Not given a
large penalty. I mean, 125 is large for this.
Yes.
This area.
There are cases referred to, I think, where there's been a breach of the due impartiality requirement, but no financial sanction has been imposed.
Right. What sort of cases were they?
It may have been one-off cases or cases that are regarded as less serious. Again, can I answer my Lord's question over the luncheon agenda? Mm-hmm. The precedent that...
There seems to be, I'm taking an impressionistic view, which is why I'm asking. My impressionistic view is that the fines they levy tend to be generally pretty small, in the sort of 5, 10, 25 level, and then there's an avosity, which the facts of which I'm familiar with, and this one, where they are in a different league. Are there lots of other examples, or are those really unusual?
I don't have, I mean, it may be that Ofcom have a better answer to my Lord's question than I do, because I don't have a bird's eye view on all the Ofcom sanction decisions.
No. But I mean, they don't go about finding people every day of the week, is the point I make.
No. Can I then deal with the interesting issue of punishment?
Punishment.
Because Ofcom's skeleton argument in this court says that maintaining the same level of penalty was necessary in order for the appellant to be seen to be appropriately punished for its conduct, thereby ensuring wider deterrence. And that, again, I'm sorry to take forensic points, but that is an evolution in their reasoning. The reference to punishing SCML, or being seen to punish SCML, is not to be found in the sanction decision or in the written arguments below. Can I just, in a compare and contrast exercise, just take you to a couple of paragraphs? If my lords and ladies turn to the final paragraph of the skeleton argument in this court, page 241 of the core bundle, and you look at paragraph 30, it reads, consistently with paragraph 1.6 of the penalty guidelines, Ofcom took the view that a penalty of this nature was necessary in order to appropriately punish SCML for the seriousness of the breaches in question, thereby to signal to other broadcasters that similar misconduct would result in penalties having a similar impact. Now, if you may, turn to page 109 of the bundle, same bundle, and read the equivalent paragraph in the admin court skeleton. Paragraph 31 at the foot of 109. Consistently with paragraph 1.6, Ofcom took the view that a penalty of this nature was warranted in order to signal to other broadcasters that similar misconduct by them would result in penalties having a similar impact. No mention of punishment there at all. And
What does it matter?
Well, it matters in this way, my lord. One might think that by focusing for the first time in this court on punishment, Ofcom are impliedly recognising that unless punishment is a freestanding objective, like it is in a criminal context, it's difficult to maintain the same level of sanction for deterrence purposes once the licence has been revoked. But the difficulty, and this is my key point, the difficulty in relying upon punishment, as Leonard Friend's skeleton does in several places, is that that would be inconsistent with the penalty guidelines that I showed you earlier. In other words, there's nothing in the penalty guidelines to which Ofcom were required to have regard by section 392 sub 6 of the Act. There's nothing in the penalty guidelines that says that a freestanding objective is for wrongdoers to be punished, akin, as I say, to a criminal context.
I mean, punishment in this context, does it? I mean, deterrence, a deterrent effect is caused by the scale of the punishment. I mean, if you're sentenced to life imprisonment, the idea is that you are deterring other people from doing the same thing because they can see they'll get life imprisonment. So calling it a punishment or a deterrent, why does it matter?
Well, in the criminal context, and again, I'm conscious that I'm not a criminal lawyer now. It's been a long time
you're
since I
not
studied jurisprudence. But the philosophical jurisprudential justification for punishing somebody is expressing moral opprobrium at what they've done, expressing society's disapproval of what they've done. And that is separate from deterring them from repeating it again and deterring others. They may be connected, they may be overlapping, but they are freestanding objectives.
Well, I mean, I would have said the analysis was the punishment is about the effect on the individual, and deterrence is about the effect on others, which is equivalent, really, to the argument we're having here with the the effect on the licensee here doesn't matter anymore because their license has been revoked, but the effect on others does.
But my lord,
But
that would be...
does the word add anything to the argument you've already stated and we've understood, which is that it was not necessary to deter others to give the same penalty as you would have given had they still had their license, because you could have achieved the same purpose by saying we would have given you that penalty had you not had your license revoked.
My lord, it may not add very much, but what one mustn't do is conflate entirely specific deterrence with punishment. So when one punishes an individual for a criminal penalty in a criminal court, it doesn't matter whether they're going to do it again. Even if the court could be completely sure they will never do it again, the penalty is there to punish them for what they have done. I mean, anyway, I can see my lord is not over enthusiastic about this line
It's
of
not,
reasoning.
it's not that I'm not enthusiastic. I think the argument is the argument.
Well, perhaps I can't improve upon it.
I mean, I always find arguments based on a close analysis of your opponent's skeleton argument having changed one word later because counsel, sometimes junior counsel, got over-enthusiastic, rather unattractive.
Oh, well, I'll move on then. Can I deal with one final topic, which I hope is perhaps more important? OFCOM argue, this is not a forensic point, OFCOM argue, they say, well, look, you can't expect people to understand a decision that says this is what you would have got, because people will have a tendency to game the system. And they use as an example of gaming the system the Club TV case. So if my lords and lady turn to the way the argument is put in core bundle tab 17, page 236.
The paragraph numbers in skeleton are good enough for me.
27.4d,
Yes,
last sentence.
yes.
A reduced financial penalty with a more lenient tariff than other licence holders would have expected to see imposed for breaches of such gravity, discounted purely on the grounds that SCML had ceased to be the applicable licence holder, would have allowed SCML to escape the penalty which its conduct otherwise merited and introduced uncertainty into the regulatory message. This uncertainty would have endured even if accompanied by an express reasoning explaining that a larger penalty would have been imposed but for the revocation of the appellant's licence. Well, to that I say, well, why? That's an assertion. Why would the uncertainty have been accompanied by a proper explanation for along the lines that we've identified? And then they say at paragraph F on the next page, this is not an abstract or theoretical risk or an ex post facto justification. In fact, it was a problem explored with the judge by reference to other cases, and the circumstances of one of those cases, Club TV, was expressly identified as a relevant precedent in the sanction decision. In that case, the licence holder surrendered its licence in advance of the sanction decision, and then advanced the same arguments on which SCML now relies in this appeal in an attempt to reduce the financial sanction. And I'm going to show my lords and lady the Club TV precedent. And the short point is that Club TV got short shrift when it tried to advance that argument.
But it isn't about Club TV answering that argument. It's about the deterrent effect, isn't it?
Yes.
If it becomes known that the regulator will reduce the penalty proportionately to reflect the lack of need for specific deterrence, then it will open up the possibility of gaming the system.
But my lady, every case, as Ofcom always emphasise in every one of its cases, every case turns on its own facts.
Well, of course it does, but there's still the need for general deterrence.
I entirely agree, my lady, but general deterrence is not a one-size-fits-all approach, and general deterrence in some cases may require one thing, and in other cases may require another thing. And in the Club TV case, the license holder, as I'll show my lady, surrendered its license in an attempt then to argue that the penalty should be reduced, and Ofcom said no. There's no suggestion in this case by Ofcom, they expressly disavow this, that SCML surrendered its license or tried to game the system in any way. So why can't other punters be expected to understand that basic distinction? They're expected to understand lengthy decisions that Ofcom say are their primary reason, their primary vehicle for conveying their reasons to the punters. And
I'm sorry I started the punting.
I'll move away
I
from
think maybe licensees would be better.
Okay,
We're on the live stream here.
Yes.
People just possibly...
Yes, no, it's my fault.
The 2 or 3 people who might be watching it probably might not understand who the punters were.
I'll be more respectful, my lord. Ofcom accept that the primary means by which they encourage other licence holders to regulate their own behaviour is through reading and understanding their own decisions. What we're suggesting is not convoluted, it's pretty straightforward. SCML would have got...
I mean, you say that it's all very well to make the sort of visceral point that, gosh, you need to have a big fine in order to deter other people, and they don't look at the detail. But you say, well, they do look at the detail, they acknowledge others look at the detail, they all got compliance departments.
They're ordinary, yeah, you have to...
They're grown-ups.
They're sophisticated
This is a very naive view, particularly under the cloud of Article 10, which is the backdrop to all this.
As my lord helpfully encapsulated my learned friend's argument, so you have encapsulated mine. Can I just show you, and this is probably the last thing I need to show you before I can move on to the concluding remarks, just to show you the Club TV case.
Yes.
As my learned friends have relied upon it. It's in the supplementary bundle tab 5, which starts at page 122. So the programme, just to give you a bit of context, the programme in this case was a imam who was, and I paraphrase, preaching hate speech and violence against people who practiced magic. I think he encouraged them to be killed under Sharia law. So there was found to be a serious breach. We see from page 123...
Sorry, is this practicing, entertainment magic? Or...
No, I suspect more religion. What was... I mean, I'm not going to purport to be an expert in what Islam categorises as magic. You can see it in paragraph 10, page 124. He, that's the scholar, made a series of statements about killing Muslim people who practiced sihr, or magic, including that the magician's art or the practice of magic can't be forgiven by way of repentance. Magicians practicing magic commit kufr under Sharia law, and it's correct to go ahead and kill them. So that was the breach.
So it's got a technical meaning, presumably.
I would have thought so.
Yes, in religious learning. Yeah.
Talmudic law I might have had a go at, Sharia law I will not. So that was the breach. Then we see in paragraph 4 on page 123 that in November 2019, having received the draft suspension notice, the licensee surrendered its license so that the licensee was no longer broadcasting. And then on the back of that, paragraph 50, page 129, we see that the licensee considered that the level of the proposed fine was unjustifiable on the grounds of deterrence, and the first point it made was that it had surrendered its license so that there was no need for deterrence in relation to Club TV Limited. And in a nutshell, what Ofcom says, look, if we allow SCML to get away with it in this case, people are going to make the same argument as Club TV made in this case. And But what's important
They're
is
all going to stop broadcasting.
Sorry?
Will stop
The
broadcasting.
miscreant will surrender their license in an attempt to...
And that will encourage other people to give up their licenses and stop broadcasting.
Well,
I mean, I have a little difficulty with the line
I'll
of
let my
reasoning.
learned friend develop what the fear is, but
Yeah.
I think that's what's said.
I'm just, it's a little odd in the light of the statutory objectives, which are to eliminate broadcasting that doesn't
Perhaps
comply.
it's to try and get away with breaching the objectives.
Yeah.
But at the moment where the possibility of a fine is going to be imposed, they surrender their licence.
I'll let my learned friend
Yeah.
explain their position. But can I show you the two paragraphs in this decision that dealt with the submission that Club TV, the licensee, had made? The first is paragraph 64 on page 131, where Ofcom said, in this case, Ofcom believed that a financial penalty was necessary to reflect the serious nature of the code breaches and to act as an effective incentive to comply with the code for other licensees. We note that although the licensee had surrendered its broadcast license, either it or persons associated with it could apply for a broadcast license at any time. Well, that's not said against my client in this appeal. We also note that it appears to have transferred some or all of its content to another provider authorised in a different jurisdiction. So what Ofcom appeared to be saying on the facts of that case, which presumably it expected people to read, was that there might still be a need for specific deterrence because associated persons might do something similar. That was what they said in paragraph 64. And then in paragraph 93, page 136, towards the foot of the page, starting about halfway down paragraph 93, they say, we took into account the licensee's argument that deterrence of it wasn't a relevant factor because the license had been revoked, surrendered. In principle, we considered that a broadcast licensee should not be able, by surrendering its license, to reduce the amount of the penalty in relation to a breach committed while broadcasting. The objective of deterring others from committing similar breaches wouldn't be achieved unless the amount of the penalty imposed was a sufficient deterrent had it continued to broadcast. Nor would such an outcome be fair to broadcasters that continue to broadcast. In addition, as set out above, the fact that the licensee had surrendered its license doesn't mean that its content has ceased to be available or that either it or those associated with it have necessarily permanently ceased to be involved. So this is quite intricate, involved reasoning, saying you can't be expected to get away with something by the expedient of surrendering your license. But that's not what my client did. So why would a decision that says the license was revoked, in SCML's case, that's different from surrender, and in those circumstances we're reducing the penalty to reflect that there's no longer a need for specific deterrence, why would that not have been a less intrusive measure? And I accept, of course, that sometimes there's more than one answer to what is the least intrusive measure. But in this case, for the least intrusive measure to be scrupulously examined, one needs to have a compelling answer as to why our suggested approach was not the right one. And there is no compelling answer. Simply saying people would get confused because they don't understand decisions is inconsistent with how Ofcom generally operates through encouraging regulatory compliance through its own reasoned decisions. That's all I want to say about Ofcom's arguments. And then finally, all I want to say about the judge's judgment is as follows. First of all, as I've already submitted, he simply didn't address the detail of any of this in his judgment, despite the fact that we canvassed similar arguments, indeed identical arguments, at the hearing before him. And second, that meant he fell into error in paragraph 26 of his judgment. If you could just turn that up. So judgment starts at page 37, paragraph 26 is at page 50. He starts by saying, on paragraph 26, the premise of Star China's submission is that there must be some form of straight line correlation. Well, I've already said that isn't. You don't have to say it's a straight line correlation. Then he says Ofcom's opinion was that in this case, effective general deterrent was achieved by imposing the penalty that would have been appropriate had CGTN continued to broadcast. There's a logic to this approach. Imposing that penalty would demonstrate to other licence holders the treatment they could expect in similar circumstances. But with respect, that's a fallacy. If the circumstances of other licence holders did not include their licence being revoked, then they weren't similar circumstances. If you're expected to be able to distinguish what is similar and what is different as part of Ofcom's justification, then you have to take into account the circumstances as they actually are. My lords, my lady, unless I can insist, those are our submissions.
Thanks very much, Mr. Brzezinski. Yes.
My lords, my lady, as my own friend very fairly acknowledged, this is a very narrow challenge. The submission is that the learned judge should have found that the Ofcom sanction was disproportionate. And as you've heard, the core submission is that if £125,000 was necessary for specific and general deterrence, as Ofcom said in its provisional view, it could not be necessary for general deterrence only. And that is wrong, we say, for one simple reason. It echoes the point that was put by the Master of the Rolls to our friend. A penalty normally serves two deterrence purposes. It deters future non-compliance by the broadcaster, and it deters wider non-compliance. The same penalty does both jobs. A penalty at the right level, reflecting the seriousness of the breach and the size of the broadcaster, will deter that broadcaster. The same penalty at that same level will deter other broadcasters. Now, in order to achieve wider deterrence, a penalty needs to be set at a level that signals to other broadcasters what penalty would be imposed on them for similar wrongdoing. In ensuring that this signal was sent, Ofcom calibrated the level of the penalty to the relevant licensee's size and turnover, just as it would be calibrated if the objective were to deter the licensee itself. If the penalty were reduced, as the appellant suggests, we submit that its wider deterrent role would be undermined. Other broadcasters would not see as clearly what kind of penalty would be imposed on a broadcaster of a certain size in respect of breaches of that nature. The learned judge heard lengthy and detailed argument on all of these issues, all of the issues raised by my learned friend today, and we say that his analysis and application of Article 10 of the Convention was unimpeachable. But even if there were some gaps of reasoning in the judgment, we say there is no such gap in Ofcom's underlying decision. And subject to the court, I propose to respond first on the authorities on the margin of appreciation. Then I'll turn to the statutory scheme, including the novosity judgment. And then I'll turn to the sanction decision, and finally the judgment itself. And I'll begin, if I may.
I don't take Mr. Grzinski's submissions to have said, to have criticised novosity in the result.
Not at all. No. In fact, the judge relied heavily upon it, and so do I.
So there we are. So that's easy. You can just say see novosity. And decide this case.
If the Master Rolls will indulge me, I will go back to those to take, because the court is looking at the issue on the substance. I will need to go back to novosity, not just for the points raised by our friend, but for the underlying harm, which is sought to be addressed by the sanction, and that's important for the court's own appraisal of Article 10.2 of the Convention. But critically, I'll begin, if I may, with the margin of appreciation, because we are squarely within, I say, Ofcom's discretionary area of judgment, or whatever we want to call it, and it's within that area that the debate occurs. And for that, I'll begin, if I may, with the Bank Mellat judgment behind tab 15 in the authorities bundle. And I'll go to Lord Reid, as my own friend did. Tab 15, and I know that page number is what you need.
.597
Thank you, my lord.
is the paragraph that was cited.
Yes, 597. In fact, if I may go back to 596, to the beginning of paragraph 71, and Lord Reid, and in these passages, Lord Sumption agreed, an assessment of proportionality inevitably involves a value judgment at the stage at which a balance has to be struck between the importance of the objective pursued and the value of the right intruded upon. And I rely upon this. The principle does not, however, entitle the court simply to substitute their own assessment for that of the decision maker. And then, if I could go to page 598, at the top of the page, we have the formulation which Learner Friend read out, emphasising at sub 3 whether a less intrusive measure could have been used without unacceptably compromising the achievement of the objective. And if I could go down, skip down then to paragraph 75. I'm not going to reread what Learner Friend read to the court, but I will take you to 75, which Learner Friend didn't read out. And there's a reference by Lord Reid to the judgment of Chief Justice Dixon in Edward's books, and the limitation in relation to the third of the criteria, so the one we're looking at, less intrusive measure, the limitation of the protected right must be one that it was reasonable for the legislature to impose. And the courts were not called on to substitute judicial opinions for legislative ones as to the place at which to draw a precise line. This approach is unavoidable if there is to be any real prospect of a limitation on rights being justified, as Mr. Blackman once observed a judge would be unimaginative indeed if he could not come up with something a little less drastic or a little less restrictive in almost any situation, and thereby enable himself to vote to strike legislation down, especially, one might add, skipping ahead, if he is unaware of the relevant practicalities and indifferent to considerations of cost. And that's obviously by a reference to the margin of appreciation that the Convention also recognises. And so, to be absolutely clear, the question was whether the assessment in looking at less intrusive remedy was one which it was reasonable for the decision taker to impose, and the courts would not substitute their own opinion as to the precise line drawn. The next authority that I wish to go to, and it was relied upon by the judge below, is the Lord Carlisle case. Lord Carlisle's challenge to the Secretary of State's decision to deny an individual permission to enter the UK. And that's begins at page 629, behind tab 16, page 629. Again, the court's very familiar with this judgment. I'll go straight to the analysis of proportionality, if I may. And that begins on page 656. Page 656, paragraph 34. And I'll begin at E on the right-hand side. The legal principle is clear enough. The court must test the adequacy of the factual basis claimed for the decision. Is it sufficiently robust, having regard to the interference with convention rights which is involved? And skipping down between F and G, Lord Sumption says the court must consider whether some less onerous alternative would have been available without unreasonably impairing the objective. The court, as we've heard today, is the ultimate arbiter of the appropriate balance between two incommensurate values, the convention rights engaged and the interests of the community relied on to justify interfering with it. But I rely on this, but the court is not usually concerned with remaking the decision-maker's assessment of the evidence if it was an assessment reasonably open to her, nor on a matter dependent on a judgment capable of yielding more than one answer is the court concerned with remaking the judgment of the decision-maker about the relative advantages and disadvantages of the course selected. And this is an entirely orthodox statement of the extent, even in relation to the convention, of the discretionary area of judgment that decision takers such as OFCOM enjoy. And the expertise of OFCOM is relevant to the extent to which it has this margin of appreciation. And that expertise was recognised, in fact, by the European Court of Human Rights itself in the Gaunt case. And that judgment is behind tab 20 in the authorities bundle. It begins at page 819. And I'd ask the court to go to page 831. 831, paragraph 61. The question in the Gaunt case was whether a sanction on a broadcaster was proportionate in view of the offensiveness of the broadcast in question that had been sanctioned. And at 61, the Court of Human Rights said, in deciding what is capable of offending a broadcast audience, weight must be given both to the opinion of the domestic courts and, to an even greater extent, to that of a specialist regulator of broadcast standards such as OFCOM, which has considerable experience of balancing the parameters, in that case of potentially offensive content, with the fluctuating expectations of contemporary radio audiences in the UK. And by analogy, OFCOM is uniquely placed, best placed, to assess what is necessary in its judgments, in its decisions, I should say, for the purposes of deterrence. I'll come to that submission later. So those are the authorities on the margin of appreciation. In relation to the statutory scheme, I don't propose to take the court to the text of the Act. Learned Friend did that. I rely obviously on section 346 sub 3, which is the power to impose a penalty on a person despite the fact that they no longer hold a license. And on section 392, which Learned Friend showed you, which is the power to make penalty guidelines. Now, before we go to the guidelines themselves, I wish to show the court briefly the procedures for statutory sanctions. And that's in the supplemental bundle, tab 15, page 200. And that begins at page 200, and if the court could go please to page 203. looking at paragraph 1.12 and following. And just to explain, the point I'm seeking to get from these passages is that if OFCOM finds a breach, there will be a written breach decision, but sanctions are not automatic. They are regarded properly in view of Article 10 as a serious matter. And even where a sanction is applied, there are a number of alternatives available to Ofcom that it will consider. And 1.12, there's a reference to Ofcom's power to impose sanctions. At 1.13, the recognition that the imposition of a sanction against a broadcaster is a serious matter. And Ofcom may, again, a reference to a power, not a duty, following due process, impose a sanction if it considers that the broadcaster has seriously, deliberately, repeatedly, or their disjunctive, recklessly breached a relevant requirement. And then a number of sanctions are available to Ofcom. Ofcom is well aware of the constraints that Article 10 places upon it in imposing sanctions on broadcasters. And at this point, if I may, I'll address the analogy with defamation cases. Now, my Lord, the Master Rolls pointed out immediately that these are very different circumstances from those that arise in relation to vindication in defamation. And my own friend, Mr. Grudzinski, very fairly acknowledged that the objectives and interests are different. I'll come back to my Lord Justice Warby's point about the common objective in a moment. But the starting point, and I have 3 points on this, the starting point is that there are important conceptual differences between an award in defamation, which has fundamentally a compensatory purpose, and a sanction, which aims to penalise misconduct and deter others. My own friend, when he was referring to the Purnell judgment, referred a couple of times to the fact that it was imposing a penalty. There was no penalty being imposed, it's compensatory damages. And similarly, vindication in defamation is a one-off, confined assessment of what steps are necessary to restore an individual's reputation, whereas a sanctions decision is designed to set a precedent for the sanctions that other licensees can expect if they commit a similar breach. And there's a particular need, we say, for a credible punishment to be seen and implemented in that context. The second of my 3 points in relation to the defamation analogy is that even in defamation cases, the likely effect of a reasoned judgment is fact-sensitive and is generally assumed to have a marginal impact. And we see that in the authority that my friend showed the court, but also in Gatley. And this goes to effectiveness. Now, my Lord Justice Warby said, the common objective may be here that both types of decisions seek to change other people's minds. But I think my Lord acknowledged that there are a range of circumstances as to when one or the other, or both, a reasoned judgment and a financial penalty, will be effective in a particular situation. And that question of what is likely to be effective is classically a judgment call for the expert regulator within its margin of appreciation. And even in a defamation context, the effectiveness of a reasoned judgment in relation to vindication is not to be overstated. And if I could take the court to Gatley itself, the Gatley's in the authorities bundle near the back. It's
not a very well-developed jurisdiction or line of authority for the obvious reason that until relatively recently there were relatively few reasoned decisions in these cases. The jury made the decision.
I hesitate even to agree with my Lord because I know so little about it, but I'm
well, that all changed on the 1st of January 2014. So it's that recent.
And I'll take, that's the Reference to Defamation Act 2013, and I'll come back to that because that is referenced in Gatley, and I submit relevant to the issue we're discussing. So behind tab 25 on page 949, one has the beginning of the section of Gatley on remedies, and I just draw the court's attention to the fact that in this regard one sees in the heading to compensatory damages. This is compensatory, not penal. About 4 lines down, the learned authors acknowledge that the primary remedy of the common law is still damages. If you go over the page to page 950, paragraph 10.002, vindication and reasoned judgment. This is a reference to the Purnell judgment that my learned friend took you to. And I draw the court's attention to the very middle of the next page, page 951, slightly above the halfway point, under the heading, the third is the correct position. This is where Lord Justice Laws said, the effect of an earlier judgment, no doubt, depends on all the circumstances, and generally speaking, the effect in relation to vindication will, I think, most likely be marginal. So he's saying it's a relevant consideration, but likely to be marginal. And by reference to what my Lord Justice Warby pointed out in the Defamation Act 2013, that is addressed at page 997 in Gatley. Page 997, paragraph 10.045, which is the new power of the court to order a summary of its judgment to be published. And obviously this is a new power, and so the authorities on it are relatively few. But at page 998 over the page, again, just above the halfway point, the paragraph begins, Section 12 of the 2013 Act builds on this jurisdiction, confers on the court a general power to grant an order that a summary of its judgment will be published, and where such relief is granted, it will go some way to vindicating the claimant's reputation, which ought in turn to have an effect on the vindicatory element of damages. However, courts have generally treated the fact of a reasoned judgment in the claimant's favour as a fairly marginal tempering factor in the assessment of damages. While Section 12 offers greater scope for the communication of the essence of the judgment to those who originally read or saw the libel, an order under this provision is unlikely to achieve effective vindication itself. It is therefore probably better to view an order under Section 12 as ancillary or complementary to an award of damages. As Justice Eadie, a judge with unparalleled knowledge and experience in the field, once remarked, any such observations relating to the innocence of the claimant contained in a judgment of the court are unlikely to achieve very much in themselves. What most interested observers will want to know is quite simply, how much did he get? And that basic question, how much did he get, has an echo in the discussion which the court was having with my own friend earlier. Obviously, OFCOM relies on its bulletin as a primary way of educating and ensuring compliance, but it is well within its margin of appreciation to assess, for the purpose of general deterrence, to impose a figure, a specific figure, because that headline figure is important in attracting the attention of other broadcasters. The third and final point I wanted to make on the analogy with defamation was, of course, and it's been pointed out to you by my other friend, OFCOM accepts that a reasoned decision may sometimes suffice for the purposes of ensuring compliance. And OFCOM does not impose a sanction in every case. It doesn't automatically follow every time a breach is found. In fact, the appellant itself, the appellant in this case, was found to have breached, I think it was the due impartiality requirement, in 2015, and no sanction was imposed. So sanctions are imposed on a carefully calibrated basis, both for specific and general deterrence. And when the sanctions are to be imposed, the penalty guidelines are applied by OFCOM. And I will go back to those. I know you saw them already today, but I'll go back and I'll try and be brief with them. And they're behind tab 16 in the supplementary.
Well, shall we do that at 2 o'clock?
Oh, forgive me, my lord, yes.
Good.
Rise.